Today is that day. You are not the law. You don't interpret the law. You don't enforce the law. You're not above the law.
Defendant Aaron York deemed guilty beyond a reasonable doubt of the offense of manslaughter. Assessed his punishment at confinement in the Texas Department of Criminal Justice for 11 years, 10 months, 12 days.
Cops often overestimate their authority and commit horrible crimes under the disguise of protecting civilians. However, today, we'll be going through these cases where these corrupt cops were owned and humbled in the courtrooms. In June 20th, 23, the Indiana State Police launched an investigation into Clark County Sheriff Jamie Noel. They discovered he had been misusing state funds, stealing over $5 million in taxpayer money to purchase luxury cars, cigars, suits, and even a personal Cessna airplane. He was immediately removed from his position and charged with 25 felonies. Here's when this corrupt cop made his first court appearance.
Date of birth?
12/18/70.
And that will make you how old?
52, sir.
And the last four digits of your social security number? Mr. Noel, Special Prosecutor Hurdle has charged you with 15 counts of criminal conduct. And I'll go through it. Count 1. Corrupt business influence is a level 5 felony. It would indicate that pursuant to Indiana Code 35-44-1.1-2-1 that on or about a period of time from November the 9th, 2018 and August the 16th, 2023 in Clark County, state of Indiana, you did knowingly or intentionally through a pattern of racketeering activity acquire or maintain either directly or indirectly an interest in or control of property or an enterprise contrary to the form of the statute in such case made and provided. Count 2, theft as a level 5 felony. You then personally sold said Hellcat for $83,000, $83,716. Count 4, theft is a level 6 felony under Indiana Code 35-43-4-2A.
Jamie's wife Misty and their daughter Casey also face multiple felonies. It's truly bizarre how this sheriff engaged in such blatant and extensive corruption while remaining in the department for so long.
September the 14th, 2022, in Clark County, state of Indiana, you did knowingly or intentionally exert unauthorized control over the property of Utica Volunteer Firefighters Association with the intent to deprive Utica of any part of the use or value of the property, said property having a value of at least $750 and less than $50,000. That being on August the 11th, 2022, you, in your capacity as Clark County Sheriff and Public Servant, did knowingly or intentionally assign to Rodney Walker, an employee under your supervision, duties that were not related to the operation of the governmental agency that you serve, that being sheriff, assigned walkery duties on your personal property, rental properties, father-in-law's property, pole barn, property of the Utica Fire Department. And count 15. Official misconduct is a level 6 felony. It would indicate that between November the 9th, 2018 and December the 31st, 2022 in Clark County, state of Indiana, you, a public servant, that being Sheriff of Clark County.
Jamie showed no remorse as he sat through the proceeding, during which the judge read out the 15 charges against him. Afterward, the state attorney argued that he should be held without bail. However, the judge eventually decided otherwise, not knowing it would later prove a mistake.
Mr. Wilder, I'll accept your offer. He will surrender his passport to you by noon tomorrow, and then you will surrender it to the court by 4 p.m. next Monday, because it's my understanding the court here is closed tomorrow.
Yes, sir.
He will surrender all firearms except one shotgun of his choice to Indiana State Police. Be it from the country, or as Mr. Wilder said, Washington County. I keep my shotgun with double lock near me, along with my 45, but I think one shotgun for personal protection is appropriate for him to maintain. will not leave the state of Indiana without permission of the court, and they'll post $75,000 in cash. This is a unique case. Mr. Wilder, I know you wanted him released without posting any bond, but it's a unique case, and if you don't like my decision, I'm happy for you to appeal it. It won't be the first time you've appealed me, and the Court of Appeals told you I was right, so I'm happy for you to accept that challenge if you're so pleased.
After announcing everything, the judge made one thing very clear.
Mr. Nolan,
Yes, Your Honor.
you keep one shotgun only. Try to deceive me, you will not like the consequences.
Yes, Your Honor.
Understand?
Yes, Your Honor.
And then, Judge, the issue of return of all other items, see if we can just take them in another hearing.
Well, it wasn't set for today, so
No,
yeah, we'll deal with that at another time. I assume now that everything's going to be unsealed, there'll be a lot of new things brought before the court that
yes, Your Honor.
we'll address in due time.
Thank you, Judge.
Anything else?
No, Your Honor.
Nothing else from us, Judge. Thank you.
All right, we'll be off record. Thank you all.
Jamie was granted bail, but it didn't last long, as he ended up breaking the sole pact he made with the judge. In March, officers raided his home and discovered multiple hidden firearms. He was summoned to another court hearing, and the judge didn't mince words this time.
You are not the law. You don't interpret the law. You don't enforce the law. You're not above the law. I find that you are in contempt of this court. Take him into custody. No, that's enough. I'll find you guys in contempt for disrupting the proceedings, and you'll be there right there with him.
Surprisingly, Jamie once featured in the A&E series named 60 Days In, and the judge made sure to reference that while punishing him for this offense.
Now, what is an appropriate sanction? The question is, I can sentence him up to 180 days without a trial, or I can sentence him to a day, or I can release him. You know what I think the answer is? 60 days in. That's what I think the answer is today.
Jamie Knoll was sentenced to 60 days in prison and is currently facing 31 felonies. He is about to go to trial soon and could be in jail for a long time. This judge really tore into the cop, but this next judge took things up a notch.
On the unclassified felony of armed criminal action, I sentence you to a term of incarceration of 6 years in the Missouri Department of Corrections.
Officer Eric DeValcanera was found guilty in the death of 26-year-old Cameron Lamb. Judge Dale Youngs announced his sentence, but had some important words for him before doing so.
The parties have a right to expect that no matter what I hear, I will only consider factors that are appropriate and that I will disregard those that are inappropriate. And that is what I've done here. And as a result, I've concluded as follows. There are a number of facts in this case that are both and mitigating, sometimes all at the same time. First and foremost is this undeniable and uncontested fact. Cameron Lamb is dead. And Eric DeValcanera killed him. That's undisputed. Cameron Lamb was by all accounts a helpful and loving son, brother, father, and friend. People who have contacted me and who I have heard from today have described him as funny, caring, giving. Miss Gray called him a protector, a jokester, and my favorite of all the ones that I read, not a saint, but our angel. Cameron Lamb's death leaves an irreparable and unfillable void in the lives of his family and his friends, and also in our community. Also, as I'm weighing all these facts, it can't be overlooked that the events of December 3rd of 2019 were initially set into motion by Cameron Lamb in his decision to chase his girlfriend through city streets at dangerously high speeds, putting motorists and other members of the public at risk.
The judge narrates the events that unfolded, and you'd be shocked to see the officer's disregard for citizens.
Those events tragically concluded with the actions of Troy Schwam, and the defendant, pulling up to defendant's house, Sergeant Schwam pulling into the driveway, immediately getting out with his weapon drawn, rapidly moving into the backyard, carport, garage area of the house, and defendant doing the same. Both without taking a breath, without pausing for the briefest of moments to consider where they were going, what they would find when they got back there, whether they were acting lawfully in doing so, and whether there might be some other safer option, without so much as a "Hey Troy, wait." At any point, Sergeant Schwam and the defendant could have done this, a fact that is made even more aggravating as the court considers an appropriate sentence in this case by the fact that the one person who ultimately did take a breath that morning was Cameron Lamb. He did this when at some point, while he was chasing his girlfriend, he decided to discontinue the chase and to go home. The video from the helicopter shows this decision, shows how it played out. Cameron Lamb is not racing through the streets of his neighborhood at this point. He's not driving through yards to get away from anyone. He does not abandon the truck and let it roll into someone's yard while he flees on foot. Rather, he simply pulls into the driveway of his home, pulls around back, puts the vehicle into reverse, and slowly begins backing it down the driveway under the carport and into his garage.
Cameron Lamb was violent by the racially motivated officer. The 26-year-old was calmly sitting in his pickup truck when this pig shot him.
Then Sergeant Schwam and Eric DeValconaire arrive, and as the court has found, an encounter that was over and a situation that had de-escalated was again escalated by what I have found, rightly or wrongly, was their unlawful entry into the backyard carport area and confrontation of Cameron Lamb. This is an aggravating factor. The circumstances of the offense as described during the trial, however, also provide the court with a mitigating factor. I found, as I've considered the evidence in the case, that the defendant, Eric DeValconaire, testified credibly at trial that he was rushing to provide cover for Sergeant Schwam, who had rushed into the backyard with his weapon drawn, prompting the defendant to do the same from the other side of the house. Although not in the court's view, again, rightly or wrongly, negating his obligation to act with reasonable care, as the court found he has failed to do, his natural reaction to protect his partner is a factor for me to also consider. And let's also be clear, and it is hard to accept this distinction, I know that. Murder and involuntary manslaughter arising from criminal negligence are two different things. They are different legal concepts. They are different things.
After siding with Cameron the whole time and acknowledging that the officer slapped him, the judge eventually started to develop a soft corner for the officer.
Eric DeValconaire is not Derek Chauvin, George Floyd. Eric DeValconaire is not one of the 3 men in Georgia convicted of running down and murdering Ahmaud. This is a mitigating factor. Defendant has no prior criminal history. His ORAS scores him as a low risk in all categories. Defendant's history as a police officer, husband and father, friend and colleague is also a mitigating factor that I have taken into account, as his father asked me to do, which I was already going to do, and that is to consider the totality of the circumstances and to consider the totality of the defendant's life. The facts and the circumstances in the history of defendant's career and his life that have been presented to this court have demonstrated he has not hesitated to immediately take action when he believed the circumstances surrounding him warranted it. And this trait has generally served him and others well. It also failed him.
Ultimately, Judge Dale announced the sentence, which felt like a slap on the wrist for this corrupt cop.
It did on December 3rd of 2019. All of which, however, leads the court back to where it began, an evaluation of the impact of the defendant's crime on Cameron Lamb and his family. Cameron Lamb is Eric DeValconaire, and the court has found that that happened because the defendant acted without considering or being aware of the substantial and unjustifiable risks associated with his conduct, and that his actions were a gross deviation from the standard of care that a reasonable person would exercise in the situation. Having concluded, as I have, having considered all those factors, I ask counsel if there's any legal reason or cause having been shown why sentence and judgment of the court should not now be pronounced.
No, sir.
Eric DeBalconaire on count 1, the Class E felony of involuntary manslaughter in the second degree. I sentence you to a term of incarceration in the Missouri Division of Adult Institutions of 3 years. On the unclassified felony of I sentence you to a term of incarceration of 6 years in the Missouri Department of Corrections. Those cases, or rather those counts and sentences, will run concurrent with one another for a total term of incarceration of 6 years.
6 years in prison for killing an innocent man while on duty feels like a light sentence. The judge extended some officers' protocol to Eric, making a joke out of justice. Eric stood still after hearing the sentence, and after a few moments, he broke down in tears. Well, this officer showed some emotion. Here's a cop who had no remorse throughout his sentence.
Court at this time will impose a sentence of 90 days, require you to pay a fine of $1,000.
Euclid police officer Michael Amion was charged with repeatedly punching a man at a traffic stop. Although Michael claimed he only did it for self-defense, the judge had a different idea.
We, the jury, being duly impaneled and sworn, do hereby find the defendant Michael Amiot guilty of a misdemeanor of the first degree in violation of section 2903.13A of the Ohio Revised Code as charged in count 2. We do so render our verdict this 29th day of July 2022, signed by all 8 jurors. Verdict. We, the jury, being duly impaneled and sworn, do hereby find the defendant Michael Amiot guilty of interfering with civil rights, a misdemeanor of the first degree, in violation of section 2921.45A.
After 5 days of trial, Michael was found guilty of 1 count of and 1 count of interfering with civil rights.
On behalf of the defendant, do you wish the jury poll?
Yes, Your Honor.
Juror number 1, is this your verdict?
Yes, it is, Your Honor.
Are these your verdicts, I should say?
Yes.
Juror number 2, are these your verdicts?
Yes.
Juror number 3, are these your verdicts?
Yes, Your Honor.
Juror number 4, are these your verdicts?
Yes, Your Honor.
Juror number 5, are these your verdicts?
Yes.
Juror number 6, are these your verdicts? Juror number 7, are these your verdicts?
Yes.
Juror number 8, are these your verdicts?
Yes.
Anything further of the jury? Ladies and gentlemen of the jury, I want to thank you all for performing your civic duty. Your job was not to prove anything or disprove anything. Your job was to determine what was presented to you, determine the facts, apply the law, render a verdict. You did that. You should leave feeling that you've done your job. No second guessing, you've done your job. If someone else didn't, that's not your job. You've done it. With that, you will be discharged. If you'd like to hang around a few minutes and talk with me, I will do that. If you do not, that's entirely understandable. Sometimes the lawyers would like to talk with you to determine how they came across to you, but again, that is your decision as to whether you wish to speak with them. With that, anything prior to discharging the jury?
No, Your Honor.
After thanking the jury, the judge ended the court proceedings. The next day, Michael, who had sat through the trial with a straight face and no visible emotions, was sentenced.
Based upon the evidence presented and the pre-sentence investigation. The court at this time will impose a sentence of 90 days, require you to pay a fine of $1,000, and will require you to pay the court costs. In addition, the court will suspend the sentence of 90 days, place you on non-reporting community control for a period of 1 year. If you violate during that 1 year, then the court will retain the ability to impose the sentence. Anything on behalf of the state?
No, Your Honor.
On behalf of Ms. Dandiot. However, given the length of time involved here, the court will use the as opposed to the violation of civil rights. Not saying they weren't violated, but given the length of time, the court will use the assault charge. Anything else?
Thank you, Your Honor.
That's all. Good luck to you, sir.
Thank you.
Michael was given a 90-day sentence, which was eventually discarded, and he was given a clean chit. However, he won't terrorize anybody again, as he was fired from the police force. Next, this officer committed something even more horrible and was rightfully sentenced by the judge.
We, the jury, having found the defendant Aaron York Dean guilty beyond a reasonable doubt of the offense of manslaughter, assess his punishment at confinement in the Texas Department of Criminal Justice for 11 years, 10 months, 12 days.
Former Fort Worth police officer Aaron Dean fatally shot Gianna Jefferson through her bedroom window while responding to a call about open doors at her home. He was charged with, and here's the footage of moments before his sentencing.
Good afternoon. The jury has sent a note or given me notice that they have reached a verdict. Are both sides ready to receive the verdict?
State's ready, Your Honor. The defense is ready, Judge.
All right. Y'all did fabulous when we did the guilt-innocence verdict, okay? Same rules apply. I don't know what this verdict is. Can't have any emotions, all right? Let's bring them in.
The officer stood firm without expressing grief or remorse as the judge proceeded with the sentence.
Juror number one, it's my understanding the jury has reached a verdict. Is that correct?
Correct.
Is it a unanimous verdict?
Yes, Your Honor.
Okay. If you hand it, please, Deputy Nicholson. Mr. Dean. Verdict reads, we, the jury, having found the defendant Aaron York Dean guilty beyond a reasonable doubt of the offense of manslaughter, assess his punishment at confinement in the Texas Department of Criminal Justice for 11 years, 10 months, 12 days. They do not assess a fine. And it is signed by the presiding juror. You may be seated. Thank you very much. Members of the jury, as we went through before, I'm going to call your juror number and ask you if this verdict is your individual verdict. Juror number one, is this your verdict?
Yes, Your Honor.
Juror number three, is this your verdict?
Yes, Your Honor.
Juror number four, is this your verdict?
Yes, Your Honor.
Juror number six, is this your verdict?
Yes, Your Honor.
Juror number 9, is this your verdict? Juror number 14, is this your verdict?
Yes, Your Honor.
Juror number 15, is this your verdict?
Yes, Your Honor.
Juror number 21, is this your verdict?
Yes, Your Honor.
Juror number 31, is this your verdict?
Yes, Your Honor.
Juror number 32, is this your verdict?
Yes, Your Honor.
Juror number 37, is this your verdict?
Yes, Your Honor.
Juror number 38, is this your verdict?
Yes, Your Honor.
Your verdict will be received and filed. Thank you very much. Mr. Gill, Mr. Brissett, is there any legal reason why sentence should not be pronounced?
No legal reason.
Mr. Dean, it's the jury having found you guilty of the offense of manslaughter and assessed this punishment. It's the order of the court you be remanded to the custody of the sheriff, be delivered to the director of the Texas Department of Criminal Justice to serve your sentence as required by law.
The jury ultimately convicted him of manslaughter rather than murder, and he was sentenced to 11 years in prison.
You will receive credit for all the time that you have served in custody on this case from the date of your original arrest up until today, which would be the date of sentence. You have the right to appeal the jury's decision. You do so by giving written notice of appeal to the Second Court of Appeals here in Fort Worth within 30 days. If you are indigent and cannot afford a lawyer, I would conduct an indigency hearing to determine if you are indigent. And if you are indigent, I would appoint a lawyer to represent you on appeal and provide you a record of this appeal of this trial at no cost. Mr. Gill, Mr. Brissett, if y'all will remain on his case pending his decision whether he wishes to appeal, and if you'll furnish the information for the trial court certification of appeal before you leave here today, I would appreciate it. Is there an allocution? You may be seated. Thank you very much.
Jefferson was also a Black American, and her killing nationwide protests claiming that Officer Dean racially profiled her. Do you think the sentence was enough, or was the officer let go easily, as many claim the sentence does not fully address the gravity of the crime? Well, that brings us to the end of this video. Today we saw cases where some of the worst police officers were humiliated and held accountable in courtrooms. It's disappointing how some of these tyrants received relatively lenient sentences, as judges sometimes treated their cases with surprising leniency. These officers must be held to a higher standard, given that they are paid to uphold the law and prevent others from breaking it. If you agree with me, please consider showing your support by liking this video, and also make sure to subscribe to stay informed about future cases like these. Also, if you enjoyed this video, check out the next video here.